Okay, welcome, ladies and gentlemen. This is actually a very important session. We have been talking since yesterday quite a lot about gender inequalities, but sometimes we forget that there are other very vulnerable groups that often are the victim also of injustices, including indigenous peoples and children in rural areas. Today we will have three speakers. Jérémie Gilbert is a professor of human rights at the University of Roehampton in the UK. And he works extensively on the rights of indigenous peoples. And he looks in particular at their right to land and natural resources. And he will make a presentation about how litigation, going to court, can actually sometimes help indigenous peoples in obtaining recognition of their rights. Because we see that non-legal tactics, such as, for example, protests and so on, are less and less effective, sometimes lead to a lot of violence. So going the legal way in some cases has been very successful. And Jérémie will talk about a bit more about that. Then we will have a presentation by Kanyinke Sena. He will be joining us through Skype. Unfortunately, he couldn't get a visa on time to come to Rome from Kenya. He is a director for indigenous peoples of the Africa Coordinating Committee in Kenya, and he's also a lecturer at the Faculty of Law at Egerton University in Nairobi. He has served as a member of the UN Permanent Forum on Indigenous Issues. Kanyinke Sena is going to present a couple of specific cases where communities and stakeholders have been engaged during the planning and implementation of energy projects in Kenya. So it will be a bit more practical, a bit more concrete case studies, but also with a strong link to Jérémie's presentation. And then finally, last but not least, Ariane Genthon from FAO, from the Decent Rural Employment team at FAO. She will talk more about child labor and really the importance of also keeping this into account when we conduct evaluations. Because often child labor in rural areas is overlooked. All right, without any further ado, I will let Jérémie start his presentation. I think he wants to show us a very short video first, just to introduce the subject. Thank you.
Hello, good afternoon everyone, and welcome to this very popular legal session, oversubscribed. I'm not surprised. So we're going to engage with the legal discourse, which I have maybe to start with an apology. I'm not an evaluator, I'm a lawyer. So really the perspective is more, what is the impact of taking a case knowing that it takes so long for marginalized community to go to a court, to actually work with lawyers that don't really understand always the marginalization of the communities, winning or losing, and then what happens? So really it's a reflection on my experience over the last 15 years with supporting indigenous peoples to take legal action, and a reflection on after 5 years after, despite losing or winning in court, what actually have we learned from the communities themselves. So I'm talking mainly based on a project that we did last year with Kanyinke, who is going to speak after me, was involved in Kenya, which is looking at Kenya, Malaysia, and Paraguay. The reason being that those communities have done a lot of engagements with the courts, and there was a need to understand, does that actually make a difference? Is there an impact of those cases of litigation that more and more indigenous peoples are going forward with? This is very much part of the more global picture of indigenous people's rights that have grown massively over the last 10 years. And one aspect of it is actually taking legal action. So I'm going to do two things over the next few minutes with you, which is, I don't know how to move this. I'm going the wrong way. Yeah. First, I'm going to talk a little bit about this report and what we've learned from those 3 sets of communities across those 3 countries. And then I want to expand a little bit more on, we could say, an evaluation of human rights law when it comes to supporting rural communities. Indigenous peoples, as I've said, have made a lot of progress in pushing the United Nations to embrace more the rights of indigenous peoples, but that means that other rural communities haven't been as much protected. So I'm talking about small-scale farmers, peasants, and other forms of communities that are, let's say, suffering from a lack of recognition of their right to land and natural resources at the United Nations level. So it's a sort of double presentation. Before I do that, to put everything into perspective, there's a short video of a case that just happened, it's about a year ago, that was the Ogiek community of Kenya. They won a very important case in front of the African Court of Human and People's Rights. This is the first case won by indigenous peoples on rights to land and natural resources. So it's very significant. And it put into perspective the will of those communities to actually go for litigation. So let's go to Kenya and watch this video, please.
Victory, victory. Yes. Victory.
This case has been a long struggle for the Ogiek community. We have been in the court, several courts in Kenya for the last 20 years, but we have never get justice.
We are excited about this, and we expect Ogiek today to have success. And this will be a milestone and a success for the Ogiek community. We are happy that finally we are on the judgment bench.
This is important because it's a defining moment in terms of determining indigenous people's land rights. It's an opportunity to finally assert that communities not only have an existing right to their ancestral lands, but that also their livelihoods are important in an age where they are constantly being pushed by different factors like climate change, like politics, to be able to be pushed to the margins. So this case is an opportunity to recognize the fact that communities such as the Ogiek, such as the Endorois, do matter. Their way of life does matter, and that their rights, even though they're in a minority, matter.
The court declares that the respondent has violated Articles 1, 2, 8, 14, 17, Sub-Article 2 and Sub-Article 3, Article 21 and Article 22 of the Charter. 2, declares that the respondent has not violated Article 4 of the Charter. 3, orders the respondent to take all appropriate measures within a reasonable time to remedy all the violations established and to inform the courts of the measures taken within 6 months from the date of this judgment.
Sasa mnaruhusiwa kuimba, wameshatoka.
tunaitoka. Wale majaji wamekata kesi. Baba wabariki katika jina la Yesu. Bariki mpaka makwao. Bariki hata magari sao katika jina la Yesu.
Very good. Very good.
Okay, thank you. All right, so I think that was just to share this victory in court, but also to discuss the follow-up. Many communities, so it was said, the Ogieki took 8 years to reach this court, but actually it took 20 years of litigation in Kenya to actually reach that level. We're talking 20 years. So the question that for us was really, will the community do that again? Is it worth it for them to invest so much time, effort, energy in trying to get such a ruling, knowing that implementation is very poor? Kenya has done nothing yet. There was another case before with the under-arrest. We're still waiting implementation. So we really went back to the communities in Kenya, but also Malaysia and Paraguay, asking them those questions. Will you do it again? What did you gain from it? What really were the impact of this litigation? So before I get on what we've learned from this, to put in context the challenge of litigation. Often litigation, as it was said earlier on, has to come as is the last resort. It's basically when there's no more legal avenues. In politics, you have no access. Development has never reached your community. You are basically invisible for the government and for some of the funders. Then, if protest doesn't work, what is left to the communities? And in most situations, that was the situation where the community told us first. We didn't choose litigation as a way forward. It just, there was nothing else left to us. We're talking about people that are so marginalized that usually they're not recognized as citizens of the states. That the states put them in a place where they've no space as being recognized entitled to actually have legal rights. So that's where they decided to go for litigation, saying, we're going to tell the government we are citizens and we have rights in this country. So it's a very political tool, despite the legal aspect. So that's why it takes so long for communities to decide to take litigation, because they have to agree that they're going to take litigation as a political exercise. But there are challenges. It's a very slow process. I don't know if some of you have been going to court, but for any issues, you're not going to get the answer tomorrow. There's nothing slower than a court. It takes so much time, energy, but also money. It's very technical. It's extremely technical. So for the communities, it's also very disempowering. They have to basically trust lawyers with big words that don't have much meaning. It's extremely formal and very adversarial, which is very against many of the culture of indigenous peoples, which are not in adversarial form, but also this formality of the court. Court system across the world haven't been decolonized whatsoever. They're still very a colonial entity where it's very formal with the judges, the lawyers, and the victims at the background can't really say much. And that is very disturbing for many communities to arrive to a court of law where actually they're basically not part of the court system because it's like a show happening in front of them. And also, of course, there's no guarantee of victory. So this is sort of the framework we went to the community saying, despite all this, despite the fact that also we have to put into perspective that those communities live really far away from the capital city where usually the court system are based. Despite all this, the communities, this is the study I'm talking about, which is available. It was commissioned by the Open Society initiative. But I want to go into what we found, really. We asked the community on different levels. What did litigation do to you in terms of material impact, in terms of the legal and political impact, and non-material impact? So in terms of the material impact, of course, the main thing for indigenous communities was, did you get the land back? Did you get restitution? Did you get compensation? The answer was systematically no, apart from one case in Malaysia, and I'm talking about 200 cases in Malaysia. So overall, we can say that 90% of the case, you don't actually get the land back. What you get, and all communities said, is a start of a process. Before that, the government ignored them, didn't want to engage on political platform. But because there's a court ruling, suddenly they feel compelled to start the discussion. So what we've learned is really litigation is a start of a process rather than an end in terms of land rights and natural resources. But communities said nonetheless, and that's more relevant maybe to IFAD work, it brings opportunities. Some of the communities we're going to talk that were involved were the Andorois that were chased from the land because of a natural park being established there, and they got some opportunity in terms of jobs and working directly into the national park because of the decision. So it does bring some material impact, but they're quite minimum. The other impact, and the legal and political communities, they all say, and I'm talking about the three countries in general, because they actually, despite the differences, it was quite similar. They say that the political impact has been quite minimum, in the sense that it's not from a marginalized community, you don't suddenly become these empowered communities. But they all agreed that it's, again, pushed a little bit the boundaries of the politics, especially on issues of citizenship. Many of the local authorities especially started to look at the communities in a different way, thinking, oh, if you're able to take us to court, then we might have actually to engage with you. So it gives them a bit of a leeway to push those institutions to engage with them. In terms of the legal impact, it's been a bit more important because most of those legal systems didn't have any protection for land and natural resources for people that rely on customary forms of ownership or cultural attachment to the land. So in that sense, it was a massive shake-up for the legal system, for the judges and the lawyers that usually were not aware that if you don't have a piece of paper which is formalized with your title to the land, which is individual, you actually might have some right to the land. So in that sense, those cases are important to push the legal system of those countries. But really what was reassuring, I would say, as a lawyer, was the non-material impacts, the community impacts. Because despite the fact that in most situations, implementation is slow, to say the minimum, when it's not ground zero, despite the fact that the political agenda hasn't changed massively, communities have been clear that they will do it again, despite everything, because they've learned a lot from this. And they felt, I know legal empowerment is used in many of the literature by reporting agencies as a big word, but actually this is what they told us. They felt really empowered by this process of learning, working with lawyers, going to court, and feeling entitled to claim their rights. And so they've said, what I've learned is the right to have rights. And that's a straight quote from one of the litigants that was involved in 10 years litigation. And that was quite common for communities. They said it was really empowering to them to realize that they're not Class B citizens. They're not only marginalized, so-called primitive people not using the natural resources in the way the government will want them to do. They're actually entitled to rights. So the right-based approach was actually very meaningful for the communities. The other important aspect was the community cohesion. They said because you have to be very organized to take those long-term cases. We're talking 10, 20 years engagement. You need community cohesion. You need organization, grassroots from the top, who is going to go to the court, who is going to be the witness, who can talk for the community. Or do you prove evidence to your land? And that meant that older, younger, women all had a role to play to develop those strategies around the case. And it said that it really shake up many of the changes in the community, the way they engage and push for change. So there was a lot on the gender impacts and also on the cross-generation impacts, with some of the younger really learning from the older generation on the connection to the land. There's a revival of spirituality, and those connection to the land that has to be proven in court, if you want, had to be put on a map and officially pushed forward. So overall, because I think I'm buying on my time, really what we learn is that there's an unlocking and reframing and participatory aspect of those cases. Unlocking meaning that when litigation comes, it was locked. There was no moving forward. The land rights were not recognized. Natural resources were not recognized to the communities. It was a stalemate. There was nothing moving forward. And they felt that litigation pushed a little bit more the agenda, revive at least the issue. Reframing, it gave this right-based approach to the communities. And participatory, because no case can be won if the community doesn't really embrace the case and is there all along the way. So that's one aspect of what I wanted to share with you. So it's not so much evaluation, but it's trying to understand litigation as a tool for rural communities, which leads me to my last point, which is what if you're not indigenous peoples as defined under, there's no definition under international, but agreement on what is it to be indigenous peoples. And that's a big issue because in most local rural communities, it's a bit more fuzzy than what people would want to assume. There's not one indigenous community there and a rural community over there. They share the land, they use the natural resources together. So that's raised the question of what if you're non-indigenous? Can you use those channels? Can you actually use those platforms? And sadly, human rights law has not been very good on that front. What I mean by this, remember we had a session on land rights yesterday. There's actually no land rights under human rights law. You can look in every treaty, it's not there. It wasn't put there with a purpose, actually. And indigenous people have managed to challenge that. What I mean by this, the right to property is individual and formal. It's not about collective ownership of communal customary ownership of the land. Indigenous people have managed to change human rights law, but the other communities haven't been included in this process. So at the end of my slide there, you can see there's a process, which is the United Nations Declaration on the Right of Peasants and Others Working in Rural Areas. It's a long title, but it's trying to capture what basically has been missing from the United Nations on this, which is we need to recognize that land rights and natural resources are crucial for those communities as well. So they need to have a platform to push the way indigenous peoples have been able to push. And one big element is the right to free, prior, and informed consent, which I guess many of you might have heard. It's one of the buzzwords of everything which is participatory in these days. There's no reason why it shouldn't be extended to other communities. It's just a human rights based on the right to self-determination and participation that we all have, not only indigenous peoples. So in that sense, we are in this moment where we need to push for the United Nations, but more human rights law in general to be much more embrace much more the fact that all rural communities are suffering from a lack of natural resources, rights, and access to land, and having a formal recognition of their customary rights to the land. So with this, I'm open for questions.
We'll do the questions.
Yeah, thank you.
Okay, thank you, Jérémie, for a very interesting presentation. I'm very glad that you don't only look at the material impacts of going to court, but also at really the non-material ones, like the empowerment and the creation of cohesion and recognition that these people have rights. And maybe in the future, the people that infringe these rights are going to be a bit more careful before doing that, knowing that indigenous peoples also can go to court and drag. Even if the process is very long, it's also very long for the respondents. It's not only for the indigenous people. So and the costs are borne usually by the losing party. So, well, many of the legal costs at least. Thank you. Now we will try to connect with Kanyinke Sena.
Hello.
There he is. Okay. Kanyinke, please go ahead with your presentation. Your slides are up.
Okay, thank you so much for giving me this opportunity to share a few thoughts. But first, let me start by apologizing that I was not able to travel to Rome for reasons that you explained, and that is the visa issues. And that may even be an evidence of inequality that we experience in some of these parts of the world that we come from. My presentation will focus on win-win investment approaches to reduce inequalities. And specifically, I'll be looking at access to energy, renewable energy, which unfortunately IFAD recognizes as a key, access to energy as key in the agricultural sector, because with energy, rural communities can do a lot of things to improve their products. But before I go into that, let me first start looking at my second slide, which will talk about what are the drivers of indigenous people's inequality. My colleague Jérémie has just... Hello? Hello?
Yes, we hear you. Please go ahead.
Yeah. My colleague Jérémie has just touched on a few cases, for example, the Ogier case. And of course, one of the key issues of facing the Ogier and other indigenous communities in Africa, especially, and Asia, and in other parts of the world, remains the issue of non-recognition in colonial times. And this non-recognition is experienced through laws and policies, through government planning processes, and of course, he has mentioned the issue of land rights, which is key in the agricultural sector. But when we look at indigenous peoples and land rights in Africa, most of their lands are classified as terra nullius, that is no man's land, or public land at the disposal of governments to do whatever they want to do with it without necessarily consulting or even taking into consideration the interest of these communities. So we also see that in national planning systems, indigenous livelihood systems are completely ignored. I don't know whether any of you at IFAD can give us an example where hunter-gatherer community livelihoods have ever been included as part of your projects. I'll very be interested to learn about that. And then, of course, laws and policies that are made in all countries that have indigenous peoples obviously lack that cultural match, in the sense that they are not responsive to indigenous people's lifestyles. For example, we talk about land laws that focus on individual ownership, which becomes very problematic for communities like pastoralists who occupy vast areas of land and they move a lot with their animals. So when I go to my third slide, I start specifically looking at the issue of energy access and indigenous peoples' inequalities. And with this, I start looking at Kenya specifically. So first, when we look at sub-Saharan Africa, we see that 62.5% of the population has no access to energy. And if we have, it's only crude forms of energy like firewood, charcoal, and etc. And in Kenya, this is 37% of the population lack electricity. And majority of these people who lack electricity are mostly indigenous peoples because of the places they come from. You'll find them deep in the forests like Mau Forest, Cherengani, the Congo Basin. You'll find them in the Sahara Desert. You'll find them in the Kalahari Desert and etc. Very remote areas that have always been ignored from the national development processes because of what they call trickle-down policies. And when we look at this, and indigenous peoples continue to suffer inequalities because they will lack services that require access to electricity. For example, hospitals, schools, and even small businesses. For example, adding value to some of their the products that they produce in their villages. So when we go to the fourth slide, we see that globally there's a shift towards renewable energy. When we look at the Sustainable Development Goals, Agenda Goal 7 talks about access to energy for all, and this includes indigenous peoples. In Africa, the African Union Agenda 2063, Kenya, we have a Kenya Vision 2030 that specifically recognizes energy as a key enabler to achieving that vision. And then, of course, we see commitments under the Climate Change Agreement, and of course, and in other laws and policies generally. But when we look at this increased focus on renewable energy and energy generally, it focuses on large-scale energy projects like Olkaria Geothermal, Lake Turkana Wind Power. These are big energy projects that are currently being developed in Kenya. So when we look at these investment models, most developing countries are focused on attracting foreign investors. And through this, their efforts to attract foreign investors, they try to create conditions that are attractive to investments. But these conditions end up actually violating the rights of very communities where those investments will happen. So in Kenya, we have what we call a feed-in tariff policy, which is encouraging independent power producers to come and produce energy. And in the process, they're investing massively in energy projects in indigenous people's territories like the Maasai, the Turkana, and etc. And then we see when these investors come, they come protected by foreign direct investment agreements, bilateral investment treaties between their country of origin and Kenya, and etc. And when we look at these foreign direct investment laws and, of course, bilateral investment treaties, they are more focused on protecting the investor more than the communities that the investment will happen in their lands. And in many cases, in fact, these communities are not even parties to the investment agreements that are being entered into. So, for example, in Kenya, we have to attract foreign investors into the energy sector. The government specifically established the Geothermal Development Corporation to prepare the ground for investors. And preparing the ground means evicting the communities where geothermal has been discovered, so that when these investors come, they don't find any communities there to get into conflict with. And then we see the approach also towards this investment is compulsorily acquiring indigenous people's territories through what they call overriding public interest. The country needs power, so you have to move away from this land so that this investor can come and do the investment in your territory. And the model is always compensate these communities and move them elsewhere. Compensate them and move them. And it's the government which determines the rate of compensation, which is actually not responsive to the market in most cases. So you'll find that they get very little money. The land that they get for resettlement is mostly smaller than the one they lose. For example, in Olkaria, the community owned 4,200 hectares, but they only got 560, which was very wrong. And these investment models, next slide, further inequalities through, further inequalities through those communities become the last to assess the energy generated from their land. For example, because when these mega projects happen, they have to connect to the national grid first, and then before the national grid is connects back to that village, it will take years. It will take years, and we have all seen that communities also lose their land and territories through such projects. They lose their livelihoods. Their cultures break up as a consequence of being moved away, and then it entrenches inequalities in many forms, and then. Consequently, we see that there's a lot of human rights NGOs then come promoting, trying to support the communities and, in essence, actually exacerbating the conflict between the communities and the government. And then indigenous, through the NGOs, indigenous communities suspend, approach complaint mechanisms like the World Bank Inspection Panel and the European Investment Bank, and then even structures within IFAD if they're there. And of course, these sometimes lead to suspension of funds, closure of the projects, and everybody loses. The government loses, the people lose, the investor loses. So these are a lose-lose investment models that we must change. But we to address this issue of inequality through energy access in the rural sector, we need a paradigm shift. So I want to give an example of what happened in one energy project, wind power energy, energy project in Kenya in an area called Kipeto in Kajiado, where this investor is developing a 100 megawatt wind energy project. So and instead of pushing for compulsory acquisition of this land, it entered into an agreement with the community to lease the land. So the community continues to retain the land, but the investor invests in the land, which was a very good model. And then the investor pays the community even during the feasibility period, which has now taken 7 years. And during this period, the payments that the investor makes, the community is able to address small issues like paying school fees for their children, buying food, building houses for themselves. So that the level of inequality actually reduces as compared to where they were, or with similar situated communities that have no similar arrangement. So, and then, but of course, the company also went a step further and gave the community a 5% equity in the company, a 5% share. That translates to almost 100 million Kenya shillings a year that the community gets. So now the community, they move from being just listers, now they are part of the company, they own the project. So this generates a lot of goodwill, which benefits the community, it benefits the company, it benefits the country at large. It's a win-win for all. And the community have embraced that project so much that when environmental NGOs at one time tried to raise an issue that the turbines we might injure vultures, an endangered species of vultures that moves around that area, the community threatened to go and kill those vultures so that the project could continue. So this is a kind of a win-win approach that the investor used that benefited them. So, but now what we want is this idea of benefits, to move from this idea of benefits to community-driven development. So when we look at the Sustainable Development Goal 7, energy access for all, 2 weeks ago at the Permanent Forum, a partnership called the Right and Energy Initiative was launched. So, and the whole idea is that if communities in their own territories that have solar, that have wind, that have geothermal power, if they can be assisted to develop these resources, it will offer better alternatives. They'll be faster, cheaper, and then to address energy access-driven inequalities in the country. And then, of course, it will supply energy directly to the community. It will minimize dependence on the grid. And then it will cut significantly on costs associated with these massive mega projects. And of course, the issue of conflict, to avoid risks and conflicts, and it promotes community livelihoods, health, etc. So, so the way forward, and I'll start by looking at what IFAD itself has said. IFAD recognizes that access to renewable energy technologies means that farmers, and that means rural communities, can undertake value addition activities, that are very, very critical, and of course that save a community from exploitation by market forces. And then, of course, productive uses of energy also contribute to providing heat and power for food preservation. That will go a long way in addressing the issue of hunger and in indigenous people's territories. And of course, so what I want to say, the last slide for us now, is to say that what we need is for IFAD and other multilateral development organizations and partners to create an enabling environment at the regional and national levels. Because when we look at what's happening, there is no enabling environment. For example, when we mobilize the community to get some funding from the African Development Bank to do an energy project in their area, some of the bank officials told us no, because it has to be decided by government. So that creates a roadblock for these communities to benefit from such initiatives that they want to drive. And of course, we want to encourage partnerships to address rural inequality in the energy sector. And these are partnerships between governments and indigenous people, UN agencies, private sector, and NGOs and etc. But of course, as Jérémie said, of course, he mentioned the issue of resources. This requires significant resources to support community-driven energy projects, which I hope that IFAD will be a partner in this. Thank you so much.
All right. Thank you very much, Kanyinke, for this very interesting presentation. It's interesting to see how you move in the approach from compensating the communities to really then involving them and actually putting them in the driver's seat and of managing their own energy projects. And indeed, thanks for the suggestions towards IFAD. Because our time is running out, I'm going to give the floor immediately to Ariane Genthon, who also has a very, very important subject and very interesting things to share with us. Thank you.
Thank you. Good afternoon, everyone. So we will switch to quite a different subject. I will thank IFAD for the opportunity to talk about child labor in agriculture. You have to know that usually when I talk about this subject, it's never from a rights-based approach as FAO. It's more from a rural development or an employment in rural areas perspective. So I'm happy to meet this challenge with you this afternoon. I will try to introduce you to the concept of child labor in agriculture, so we have all the same understanding, and explain to you why child labor is hampering our efforts for rural development, and we'll try to explain you why child labor is not only a child rights failure, but it's contributing in general to reinforce inequalities over time and across the community. Child labor is a manifold failure. I will try to also, from a rights perspective, emphasize and clarify how it is a compounded and cumulative rights deficit that is entailed by child labor, and how this relates to inequalities. So let's start with providing you with a basic understanding of what is child labor in agriculture, why it contributes to perpetuate poverty, why it undermines our effort of rural development and developing a good agriculture. And I would try to give you also some example of what is trying to do FAO at a country level, what kind of initiatives. All right, so let's try to have all the same understanding. So when we talk about child labor, we don't talk about all the activities that are being undertaken by children, no? We talk only about the kind of activities or at least the way that those activities are being undertaken that are detrimental to the child. Child labor in general, the notion has been coined and is being very well defined in ILO, International Labour Organization conventions, and there are 2 conventions. I will go back to that later on. But in the meantime, just so that we are all at the same level of understanding, I will give you some criteria that will guide you. Child labor is what is mentally, physically, spiritually, socially, or morally dangerous and harmful to children. It is what interferes with compulsory schooling, and you know that usually it is defined at national level, but there are some international also provisions that I will describe later on. It is the kind of activity that engages children below the national minimum employment age for that type of work, or work that is hazardous. There are a lot of notions here. I will try to help you understand them. Why it is important to talk about child labor, because it is a global issue. Let me also clarify that since child labor is defined by ILO Convention, it is also a topic that is being, for which ILO has the responsibility in the UN system. FAO is working on it, but only for the agricultural sector. So the ILO collects on a regular basis and based on a very elaborated statistical method data related to child labor worldwide. The latest global data have been released by ILO in 2017, so they are quite recent. What they show you is that child labor is overwhelmingly in the occupational sector of agriculture. It's 71%. And the bad news is that the numbers, instead of decreasing despite the effort of the international community, have been rising in the agricultural sector. So the prevalence from 59% in 2012 is now of 71%. The number of child labor in general in agriculture have also increased of 10 millions. And you have to know that in the agricultural sector, the majority of child labor is unpaid family labor, which is an important characteristic. By agriculture, just for let's say, colleagues not being in Rome-based organization or not familiar in general with the definition of agriculture, we do intend farming, aquaculture, fisheries, forestry, livestock, so animal husbandry. All those activities are captured here by what we call agriculture. Okay, let's go back to what is, let's say, the focus or at least the angle of our session, or rights-based approaches. So child labor is enshrined in several international instruments. It's a principle that is embodied in the Constitution of the International Labour Organization. As you know, it's really the oldest UN agency that was founded in 1919, so it was already there, the principle of efforts to tackle child labor. It is one of the organization's 4 fundamental principles and rights at work. So for those of you who are legal practitioners, it means that it is used against. So even if countries haven't ratified the 2 labor conventions that I mentioned to you on child labor, which are 138 and 182, member states of the ILO are, however, responsible to implement and undertake efforts to tackle child labor in their respective countries. The principle is also enshrined in over human rights treaties, including, of course, the Convention on the Rights of the Child, and it's more coined under the provisions related to exploitation, and you find it also in the Universal Declaration of Human Rights and over important international covenants, the one on civil and political rights and the one on social, economic and cultural rights. You have to know that in the current SDG and the Agenda 2030, there is a dedicated target. It's SDG 8.7 that is related to forced labor and child labor. All right. Why it's important to work on child labor in agriculture, and why we think and we have observed that it is perpetuating rights deficits and poverty in rural areas. I leave you have a look at this, what we call the vicious circle of poverty. It's just to try to show you how over a lifetime and across the community, child labor contributes to maintain a rural community in poverty. So the main push factor for child labor in agriculture is usually poverty and or hunger, no? So children will supplement the income of adults in the households just to meet basic needs very often. So they are sent to work, or maybe they are just working on the family farm and contributing to the productivity just to produce the food, no? That is needed. So children are supplementing or substituting adults because just there is not enough workforce within the family or on the farm, and so children are contributing also to grow just what family needs to meet their food needs, let's say. The fact that children are involved in those tasks, it's not only detrimental to the children, it's detrimental in general for the work being done, because children are just not skilled, they don't have the strength, they don't know how to conduct some of these tasks, and so it might contribute to food loss. It might contribute to have some adverse impacts on just on the productivity in general. So children enter the labor force early, and mostly in agriculture it is observed that they are in the worst forms of child labor. By worst forms of child labor, and sorry for being a bit superficial in all the definition, but here we don't have much time, the convention says that the worst forms of child labor are of 4 types. In agriculture, mainly what you can find is what is called hazardous child labor, which means that those tasks by nature or circumstances are putting the health and so the very life of children at risk, like spraying pesticides. It's a very typical hazardous task, example of worst form of child labor related to hazardous child labor in agriculture. Another form that is widespread in some countries, it's what it's called debt bondage or forced labor, meaning that children are going to work in agriculture to repay the debt of a family of farmers because their family have contracted those debts just because maybe the harvest didn't go well, and so they have debts that they need to reimburse, and so the child to compensate that goes working. So these are 2 examples of worst forms of child labor that you will find in agriculture. And it's in agriculture, it's even more prevalent than in other sectors to have worse forms of child labor. So you have low school enrollment, because in general, you have children, of course, combining work and school, but in the end, it's mostly children dropping school and working only. And you have reduced health of children because of the fact that they are undertaking tasks that are not fit for their age, development, etc., leads to impaired development of children. You have children that will become young people and that will be trapped, and that is demonstrated in various ILO reports, which I'm happy to share with you the resources, will be trapped in unskilled and precarious labor. Why? Because those children didn't have a chance to finish primary education, or even if they had the chance to, they didn't have the occasion to access relevant or quality education in rural areas. And as young person, they might not want, as previous child laborers, to stay in agriculture or to stay in rural areas. So you have also the issue of young people choosing just to leave rural areas and not continue in agriculture. You have low adult wages and weak bargaining capacity. Why? Because child labor is cheap. So if you have children working, you have adults that have less power of as workers to bargain. And here I'm talking about not only family labor, but in that case of waged employment. You have a reduced capacity of communities to innovate and respond to shocks. Why? Because if you have been as a child worker already from a young age, you didn't have the occasion just to learn how you can do agriculture differently and to learn about good agricultural practices that actually can be more productive, more responsive to shock, more respective on of the environment. You have low agricultural productivity, low performance of rural economies, and we go back to poverty. So it was just to show you that not only it has an impact on what the future adult will be, the adult that was as a child involved in child labor, but also the fact that it has a consequence on the rural community. All right. Child labor derives also from a rights deficits in rural areas. I just wanted to a brainstorm review on the fact that, for instance, we said that hunger was a push factor, no? So you have a right to food that is not respected. You have also gender equality that is an issue because very often children find themselves in child labor because there is not a good household division of tasks in farming or in agriculture. So gender equality can be a powerful rights-based approach also to diminish child labor. It's of course a decent work issue, and it's a child protection issue at large. In a nutshell, FAO response to child labor in agriculture consists in integrating better agricultural stakeholders, giving them a voice, involving them in all efforts that are related to policies and legislation addressing child labor. It's very typical, the kind of child labor that you have in agriculture, and agricultural stakeholders have a voice and a great role to play. It also consists in incorporating child labor within relevant agriculture and food security policies and legislation. Just very superficially, I'm giving you some examples. You will see in the middle, when we tried, for instance, in the FAO Code of Conduct for Responsible Fisheries, you have a provision related to child labor. You have it also in the International Code of Conduct on Pesticide Management. It is also included in the contract farming for those of you who work on inclusive business approach, etc. And in terms of how we work at country level, it's mainly in terms of collaboration, partnerships. So as I told you before, it's a manifold failure. So it's not only Ministry of Agriculture or Ministry of Labor, but it entails to work across ministries, and entails also to work with different partners. And I wanted just to mention to you that, for instance, we are here in IFAD, and there is an international partnership from which IFAD is a member on cooperation on child labor in agriculture, together with ILO, IUF, which is a trade union, and IFPRI. concluding very briefly, so you have legal obligations that are relating to child labor in agriculture and are found in a number of legal instruments, core convention on human rights. It's a cross-cutting issue. It derives and generates rights deficits that contributes, unfortunately, to perpetuate inequalities. And agricultural policies can have an impact on child labor elimination efforts, but very often it is overlooked, that potential. I think I will conclude here, just not to use too much of my time. Thank you.
Thank you very much, Ariane. It's a pity that there is not more time to talk about this extremely important subject. I don't know in IFAD if our social, environmental, climate assessment procedures take child labor into account, but I'm ashamed actually to say that in our evaluations we hardly ever touch upon the issue, and I think it's a wake-up call for us that in evaluation we should also pay more attention to this sometimes very dramatic situation in which children can find themselves in rural areas. Okay, now our session time is up, but I think we will take 3 questions. I would ask you individually only to ask one single question and be very precise in what your question is. Then we will be able to have 3 questions from 3 different people, and then I will let our panelists answer. Thank you.
My question is for Mr. Gilbert. You mentioned that there were no rights to land. Are the voluntary guidelines on the responsible governance of tenure of land, fisheries and forests in the context of national food security of any relevance to the work you're doing or to the work that Mr. Sena is doing? You did not mention it, so. Adopted by your CFS in 2012.
Okay, one more.
My name is Walter Mandela. I work at IFAD. My question is, when you're litigating, especially in the African context, what's the methodology for determining who's indigenous and not, considering everyone is indigenous?
Great. And one more question, please. Yes.
I think a lot of what you said about child labor in agriculture is exaggerated. It's not consistent with a lot of observation, not consistent with a lot of research. There are certainly many anecdotes we've heard of children being exposed to hazardous work and the spraying example you gave, but I don't think it's a balanced representation of knowledge. I can point to particular studies. For example, there's not actually a lot of evidence that unpaid work in family farms substitutes with schooling. In fact, there's almost very little. It seems like the margin of substitution is between leisure and working on the family farm. In other words, schooling is pretty much unaffected. There's some. It's not. That's a generalization, but I think it's a fair one of the research by economists, at least. I think most economists have come to the view, pretty much, that unpaid family work by kids in agriculture is way secondary, let's say, to the worries we have, and serious worries we have, about child labour in industry and paid child labour out of the home. I don't for a moment deny that that's a problem.
Sorry, sir. You are? Can you introduce yourself? Just tell us your name and your affiliation.
Martin Revalian.
Okay, thanks for raising the FAO voluntary guidance. I wish I had time to speak about them because they are a fantastic piece of work. The problem is in the title, voluntary. So it's very useful for advocacy purposes, and we always use them in the litigation, say it's there, it's relevant, it's actually pushed the border of where the law is at. And hopefully we can use this to the next step, which is to get a UN declaration. So clearly they are essential, and that's a good thing we have them, otherwise we'll be very naked in front of the states to get anything pushed forward. So they're good at that level, but also they're good for pushing states say, look, it's not very challenging. You're already doing it in one way or another when you follow, because actually states have engaged quite well with the voluntary guidance, despite the fact they are voluntary. So it's a very useful tool, clearly. No, the end game is actually to transform this into a treaty, but there's still a bit of mileage before that. The other question on methodology, there's no methodology to define those peoples. And that would be very dangerous, actually, if there was one. It's the old colonial game. Colonial powers arrived and did exactly that. So the approach is self-definition. Indigenous peoples, you don't tell them who they are. They come to us and say, we are indigenous peoples. We want our right to be recognized as indigenous peoples, which might sound very encompassing in that any communities in Africa could claim this. But in reality, it draws down to communities that are so marginalized and they have this connection to the land which is so specific that actually there's not that many communities that naturally feel entitled to this. That's the practical issue. The reality, we use the working group definition. So 5 years ago, the working group of the African Commission on Human and People's Rights came up with a long report which does exactly this, which is trying to define who are indigenous peoples in Africa. And it goes through a long process of definition to arrive to the same conclusion that the main thing is indigenous peoples themselves should decide if they are indigenous peoples, but adds a long list of people that are concerned, which are mainly pastoralists and hunter-gatherers. So I will say this is the way we put it in the litigation, and that's the way it's been successful. Say this is the working group of the African Commission that has defined these peoples in that way, even though there's no officially labeled definition, because that would have been too dangerous to do that. That's my answer, but Kanyinke, if you're still there, you probably can add a lot, because in Kenya it's been a very raw issue of who is indigenous, who is not. Kanyinke? Oh, we've lost him. But
Thanks for your question. Actually, I would be interested to know about the research you were pointing to that, because it's not me saying that, it's ILO. So I think it would be interesting as a reading to go to the latest estimate on 2017 that just demonstrates... Shall I continue? Okay. That demonstrate, on the contrary, that even if children combine school and work, which is not often the case, and I invite you just to look at the global data. It might be the case for the first years, but for sure when children reach 12 years onwards, which is still below the minimum age for work, because worldwide the minimum age for full employment is either 14 or 15 years old, you have a very high dropout. You have also the ILO Global Report on the pathway to youth employment, which is 2015, and that show you how children that were previously involved in child labor will be trapped into unskilled and precarious work for the rest of their lives. The issue is more pressing in agriculture, and that's what the ILO estimates demonstrate, because you have just 71% that is corresponding to the definition. You can also, if you're interested to just go deeper into that, look at the UCW. It's the Understanding Children's Work. It's a research institute that is being financed by UNICEF, World Bank, and ILO, but is really looking into that, on the relationship between child labor, how it is effective later on in the life cycle, future use, how in agriculture and rural areas does it hamper or threaten the capacity to access education for these children, and economically does it mean that it will also hamper at local level the development. You have quite good sources there, so yeah, just invite you to go deeper.
Likewise.
Right. Thanks once again, Ariane, Jérémie, and Kanyinke for your great presentations. Thanks also to the audience for your attention and your good questions. And unfortunately, we have to stop here, even though this could have been the subject of a full two-day conference, probably. All right, thank you very much, and see you in the next sessions. Cheers.
Hello?
Kanyinke. Would you like to say something?
Yes.
Would you like to answer one of the questions?
Sorry.
No? Okay.
There's a network issue, but I just wanted to briefly add on what Jérémie had mentioned on the methodology, and of course to speak about the work of the African Commission Working Group on Indigenous Populations, of which I'm a member. I wouldn't go into the details, but they went into not on the first people's idea of who came where first, but they kind of used certain characteristics. So what I'll do, because of the time is up, is that I'll send you that report. I'll send you the report so that you can share with the rest of the workshop participants. Thank you.
All right. Thank you very much. And goodbye. Cheers.
I can